Under Wisconsin law, could he have requested a bench trial with no jury?
I don't know. That varies from state to state. So in some states, the defendant has an absolute right to a bench trial if they want it. This happens. This is the law in Baltimore, for example, where we had the Freddie Gray prosecutions some years back. Freddie Gray was the street corner drug dealer who got arrested in a drug sweep, put in the back of a van. And when the van arrived at its destination, he had a broken neck and died a few days later in the hospital. And 6 police officers were charged in his death with crimes as serious as murder, even though there was literally zero evidence that any officer used any unlawful force against them at all. There was no evidence, purely politically brought prosecutions. But in Baltimore, in Maryland, I should say, the defendant has an absolute right to a bench trial if they want it. The prosecution has nothing to say about it. And of course, this was very frustrating for the prosecution because, the cliche is if you're innocent, you want a bench trial. Because if you're innocent, you want the judge to play the role of the jury. That's what a bench trial means. There is no jury. The judge is the finder of law and the finder of fact. And the judge is, in theory, a legal professional who'll be unlikely to be persuaded by merely rhetorical arguments by the prosecutor, who's a professional who'll focus on the actual legal merits of the case. So if you're innocent, you don't want to run the risk that a jury could be persuaded by the prosecution by fancy words. So you want a bench trial. Conversely, if you're guilty, you want a jury because you're hoping to convince one of the jurors to vote not guilty, and then at least you have a hung jury. So in Maryland, you can demand a bench trial, and then you get it, and the prosecution there's nothing they can do about it. In other states, however, the prosecution has to agree. So in essence, in those other states, the prosecution is seen to have a right to a jury as well if they want to argue to one. I haven't looked to see what the law is in Wisconsin, but of course it's very hazardous. It's because then you are putting your entire fate in the hands of one person. Yeah. And if that person proves politically motivated, listen, if they want to, they'll come up with a rationale to find you guilty. And it'll be word salad. It'll be nonsense, but you made that choice to put the decision in their hands. So very risky. I suspect, given who this judge is, if they had the option to demand a bench trial and get it, that they would have. I think I would have. Yeah. So I suspect that he doesn't have that authority to demand a bench trial himself, that the prosecution would have to agree. And the prosecution would never agree in this case.
Yeah, with Rittenhouse, if I was Rittenhouse, I would definitely try to get a bench trial if I could, because from what I can see, it looks pretty clean.
Hey, folks, a little follow-up on this interview question by Rich Brown. On the issue of whether or not Kyle Rittenhouse could demand a bench trial. At the time of the interview, frankly, I hadn't yet checked Wisconsin law on this issue, but after the interview, as you might imagine, I went ahead and checked Wisconsin law on this issue. And it turns out that a defendant in criminal court in Wisconsin does not have an absolute right to a bench trial, but rather, if they desire a bench trial, they must first obtain both the approval of the court and the consent of state prosecutors, and that's per Wisconsin statute 972.02, subparagraph 1, for those who'd like to look that up. In the Rittenhouse case, of course, the prosecution would never consent to a bench trial given the lack of legal merit to their charges against Rittenhouse, so I'm afraid it's a jury trial for Rittenhouse, period, no matter how much he might prefer a bench trial.